Richard Allen is requesting that his 130-year sentence be vacated and he gets a new trial. And I'm going to go through the document he's using to attempt to do that. Now, with that being said, I do want to make it very, very clear. I was not able to follow this case while it was actively going because I was covering Sarah Boone's case extensively. So my knowledge of particulars is extremely low. But I do know that a large amount of people requested I cover this case, which means that many of the viewers are probably very aware of this case and might not know or have seen this full document. So I thought I would share this, and maybe if anyone in the comment section would like to talk about if they think anything here holds water, would let us know, because as someone who followed along with the Sarah Boone case, her appeal attempt seems not great when you've actually watched the full trial. I also want to make it very clear, I am still sick, so I apologize for the quality of the video if it's not good. In violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding of November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel, and under United States v. Chronic, in its progeny, the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. Now, my immediate thought, personally, is, shouldn't this have been brought up by his lawyers before now? And was it brought up before now? Because he obviously got represented at some point. We have transfers for personal safety or safety of others. Upon motion by the sheriff, prosecuting attorney, defendant, or its counsel, attorney general, or court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or a facility of the Department of Correction designated by the Commissioner of the Department as suitable for the confinement of that prisoner, and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. Indiana Code, that's a number, also governs safekeeping proceedings for pretrial detainees and provides in full post-transfer hearing right of inmate to refuse transfer. An inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27, 2022, Kathy Allen, Mr. Allen's wife, hired attorney Brett Gibson to represent Mr. Allen. Exhibit 1, Affidavit of Kathy Allen. In the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McLeland, the Carroll County Prosecutor. Exhibit 1B. What emerges from defendants' exhibits 1C and 1D is the following. Sheriff Lazenby confirmed receipt of, remember, I've not heard these names, so I'm going to try to read them. Confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27th. Also on October 27th, however, over the phone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McLeland by email, after which Mr. McLeland called Mr. Gibson on his cell phone. Mr. McLeland told Mr. Gibson that Mr. Allen was listed at the jail under a different name alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson the regular staff did not know Mr. Allen was there. Still on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. At about 10 p.m. on October 27, 2022, Mr. Gibson called Mrs. Allen, to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day, Exhibit 1. On October 28, 2022, without Mr. Gibson, as you can see here, the title is Richard Allen, Motion to Correct Error, and I was reading from there. Without Mr. Gibson present, even though Mr. McLeland and Sheriff Lazenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder. the judge Diener held Mr. Allen's initial hearing. Shortly after this initial hearing on October 28th, Mr. Allen was whisked away from Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On October 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there. It was shown filed in this court on November 9th, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in Houston v. Lack, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. That's actually good to know. I'm assuming it's accurate, right? That's really good to know. So when Sarah Boone was acting pro se, they technically were filed the moment she handed it off. The safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lazenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. Next, Sheriff Lazenby had no standing to make the safekeeping request on October 3rd, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff, statutorily authorized to make a safekeeping request under Indiana Code. Because Sheriff Lazenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. Here they have an example. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. And here we have a case. A judgment is void if it grants rights or relief to a party that does not have the standing to pursue the action. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lazenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lazenby, helping Sheriff Lazenby draft his safekeeping request in violation of Rule 3.1 of the Code of Judicial Conduct. Rule 310 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9 of the Code of engaging in substantive ex parte communication with Lazenby by helping Lazenby draft Lazenby. I'm going to get killed in the comments for how I pronounce it, I'm sure. Draft the safekeeping order specifically were. Draft the safekeeping order, which helping Lazenby draft the safekeeping order explicitly were. Having violated Rules 310 and 2.9, Judge Diener was obligated under Rule 211 of the Code to recuse himself in the request appointment of a special judge before issuing the safekeeping order, not after, which is what he did on November 3rd. Also see Rule 211 of the Code, Comment 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. I mean, as someone who's not watched the case, it doesn't sound good for the judge and the sheriff. I'll put it that way. It doesn't sound good. Is it vacating verdict? I don't. Third, Sheriff Lazenby's November 3rd, 2022 request for the Sheriff of Carroll County, Indiana to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached. Indiana Code requires a safekeeping request be made by motion. Indiana trial rules require that Sheriff Lazenby motion for a safekeeping order be served on the parties. Because Sheriff Lazenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. Even if he claimed Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lazenby was required to then serve Mr. Allen personally. Fourth, Sheriff Lazenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana code that would authorize a safekeeping order. Fifth, because a factual finding was required to authorize a safekeeping order, a hearing with notice to the parties on Sheriff Lazenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lazenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. Mr. Allen had no opportunity to exercise his right to refuse a transfer to the Indiana Department of Corrections custody or to make any of the objections set out above the entire course of proceedings. That is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility in Cass County Jail for 23 months pending trial. Okay. Huh. Okay, my opinion on this already kind of just shifted a little bit. Remember, I know very little of the case. I remember there was, I believe, there were things he said, Richard Allen said, that it seemed to be like a mental health issue, possibly. Like people thought it was. I'm just from memory, I could be wrong. 23 months of solitary. And the 23 months of solitary were not even, if it's true, they weren't properly done. I'm seeing how if this could be tied to some sort of a confession or something that Richard Allen said or did, I'm starting to see why they're going this route. Not saying that this is what happened or it's accurate, but going off of what they're saying, now I'm seeing why it's in this document. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceedings should be treated no differently from absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards trained lawyers. One consequence of this should be that the Sixth Amendment in Article 113A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has a right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any stage of a criminal prosecution. Chronic. The safekeeping proceeding, such as it was a critical state in which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all objections to the November 3rd safekeeping order set out above. Critical stage is one holding significant consequences for the accused. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel. Alternatively, before we go to that, I have this down here. The court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in an Indiana Department of Corrections prison and was shackled, leashed, hooded, and deprived of human contact. See Wolfish v. Bell, violation of due process for a pretrial detainee to kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic. See, I did remember. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding. Okay. I mean, it has more sway than anything I heard in the claims by Sarah Boone. I'll put it that way. But I'm still just wondering, like, was this brought up before? And does it matter if it was brought up before? Because, I mean, this sounds bad. Like, it sounds at the least, I'm not saying, like, vacate immediately, right? But at the very least, something, if this is accurate, something should be done to those that led to this, right? The judge, the sheriff. Alternatively, Article 113A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens ever greater protection than its federal counterpart. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but the rights afforded under Section 13 also attach prior to the proceedings of formal charges against the defendant. And the right to counsel attaches upon arrest. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceedings. This should be particularly disturbing because he has been given the opportunity to do so. Mr. Allen had the absolute personal right to refuse transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. I think if that's accurate, that deserves a hearing. That's my opinion right now of someone who didn't follow along with the case as well as he'd like, just kind of read snippets. I had people messaging me on like my Discord that also follow true crime, telling me stuff. Those sound bad. And for a personal opinion, and maybe for a selfish reason, now that I've heard these accusations, I want a hearing to know whether it's accurate. And maybe that's the goal, right? Maybe that's the point. Maybe this is to get people like me to say, wait a second, this sounds bad. We should have a hearing. Maybe there isn't all that to it, and it's more designed for the public's response. But I always think about that. Expect like more and more after like following Sarah Boone, because we know the spectacle. A lot of the spectacle was for us, right? Sarah did that on purpose because she thought she could get people on her side. And I'm sorry if I'm like drinking a lot. I did some like I had to do some stuff outside the house. I didn't leave, but like I had to do things outside in the cold, and my throat's been not great since then. In violation of the Due Process Clause of the 14th Amendment and Napua v. Illinois and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van around 2:30 p.m. on February 13, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. So, I'm sorry I'm taking a bit here, but like it's taking a bit for me to like really, I want to let it sink in as I go. So they're claiming that this white van, I don't know exactly. I think the white van was used, again, this is all from memory. I try to follow a lot of things. I think the white van was used to try to justify a time frame that Richard Allen did something. So if the time is wrong, that's a problem. A conviction obtained through using false evidence known to be such by representative of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. At trial, the undisputed evidence was that LG's cellular phone stopped moving at 2:18 p.m. So the phone stuff, we heard similar with the burn pile murders. Burn pile murders use a lot of cell phone stuff. For 7 minutes until 2:25 p.m., it then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McLeland called it a hard fact that LG's phone stopped moving at 2:32 p.m. The state introduced an alleged confession and are using alleged by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. So this sounds like this is going to be taking place during the time where they are arguing he was, let's call it torture, right? That's what they're suggesting, against it while violating his rights. This happened. In this alleged confession, Dr. Wallace stated Mr. Allen had said he had abducted LG and AW on the south side of the Monon High Bridge. Wait. Someone has to tell me. When she says Dr. Wallace stated, is this alleged confession not recorded? Maybe you don't normally record like a psychologist meeting, but like I don't like the I am someone who people have some of the stuff I've covered like why are the body cams audio so bad or the interrogation audio so bad. I hate that. I think it should be clear. I just don't like. I don't like this because if this document is nonsense, right? If this document is nonsense, but they're not inaccurately describing things. The way this is worded to someone who reads this doesn't sound like I'm not sure it's written that way. It sounds like the sheriffs and the correctional facilities gave the defense a lot to work with. I'm going to leave it at that so we can continue. That's what I'll say. My feeling right now. Dr. Walla stated Mr. Allen said he had abducted LG and AW on the south side of the Monon High Bridge and forced them down the hill to the south side of Deer Creek. Dr. Walla said Mr. Allen said he was on the south side of Deer Creek and was planning on sexually assaulting LG and AW when he was interrupted by a van. I'm presuming that's going to be the van above. Dr. Walla said Mr. Allen said he had become scared when he saw the van and crossed Deer Creek from south to north from the Weber property to Ron Logan's property, taking LG and AW with him. The state also introduced a testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13, 2017 and arrived home in his white cargo van at about 2:30 p.m. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at about 2:30 was a detail only the killer would know, said the state. But the problem is the state also contended that LG and AW died near in time to 2:32 p.m. when Apple Health data from LG's phone showed the phone stopped moving. If the arrival of Mr. Weber in the van interrupted Mr. Allen, forcing him to cross Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m. when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44 and 54 p.m. on February 13, 2017. His arrival at about 2:30 could not have been a detail only the killer would know because it did not happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. Defendant's Exhibit 3A, attested to by Matthew Kaufman in Defendant's Exhibit 3, is a video recording made on February 13, 2017 by a security camera that was in the house at 5998 West County Road 252 North. The video recording was provided to the defense by the state and has therefore been in the state's possession. Okay, hold up. I'm detailing back to make sure I get this. So at the trial, they give this time frame of events, right? Now, a phone not moving doesn't mean killing, but it means it's not moving, right? So it's not moving at 2:32 p.m. But Mr. Weber could not have arrived anywhere on the private drive before 2:44. That's interesting. I mean, there is a possibility that the time on the security camera is wrong. Huh. So we have phone data used by the prosecution, and then we have an impossible time frame, at least according to this document. I'm going off this document. An impossible time frame being used to corroborate a assumed confession, an alleged confession, that could have been under duress. Psychotic episode, possibly brought on by an illegal solitary confinement. My thoughts right now are, I feel bad for the family of the victims, because maybe it's just because of the way it's being presented, but this is very well presented. There's gonna be people in the public that are gonna see this and believe he's innocent that might not have before. Whether he is or isn't, the fact that that's now being ignited alone is going to be bad for the families of the victim, right? Mentally, it's not, because they're gonna see it. People are gonna talk. And if this ends up going to, they end up vacating and having to redo the case, this is, man. Let's keep going. The security camera faced west, northwest, and appears to have recorded continuously. Based on the date and timestamps of the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind. See, see, this is how you know that I haven't actually pre-read. Maybe you'll suspect it now. Actually, I didn't know that it was wrong. My assumption is people, if you can manually set a time, they set it wrong. The amount of times I've been with someone and like I look at a car clock and it's like 15 minutes off. That's why my mind went to that. It could have been off, but let's continue. The time on security, and that's probably what the prosecution should be able to see if the timing hasn't been changed since then. It's been continuously running, but we'll just keep going. The time on security camera is set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. Security camera had a wide-angle lens that captured video of traffic at the beginning of the private drive to the Weber property, which, okay. A lot of these are not, like, according to the time and day stamps of the security camera reporting, Exhibit 3A shows a white van going northwest, entering the frame at approximately 2:33 p.m. Exhibit 3A also shows a white van coming into the private drive at the Weber property at approximately 2:44:54 p.m. Exhibit 3A is viewable on YouTube at the following address. Alright, so this might be hard for you to see, but up above my head, you should be able to see the end of that field. There's two little houses in front of that tree. There's some building. Just watch right up above my head there. That's it moving right now. Now, the second video that they have is basically a zoom in of it. I'll just get to a higher zoom in so you can see. See it there? So that's what we're working off of. I wouldn't say that was definitive of anything personally. And the comments seemed very, some of them supportive that this is proof. Some of them are like, that's obviously not the same band. So let's just continue and see how they explain it. Exhibit 3B, which is the second one we watched, is a video file that contains 3 zoomed clips from the video recording that is Exhibit 3A. Each successive clip in Exhibit 3B is zoomed to a greater magnification. Exhibit 3 and all 3 zoom clips of Exhibit 3B, a white cargo van going north just after 2:44:33 p.m. on February 13, 2017. Exhibit 3B is viewable on YouTube. So the fact that these are publicly available on YouTube makes me feel this is for the public again, honestly. More than anything, to bring up that speculation and maybe public pressure for a new trial. Exhibit 3C is a PDF with still photographs taken from Exhibit 3B at each magnification level. For each magnification level, zoom level 1, zoom level 2, zoom level 3, there are 3 stills showing the white cargo van just before it passes the white sunlit house in the background on the west side, as it blocks the sunlit house just after it passed the sunlit house. Reproduced below is the first photograph on page 3 of Exhibit 3C, showing a circled white cargo van before it passes the sunlit house on the west side. So if you didn't see it before, maybe it was really hard to see, there it is in a photo. Exhibit 3D is a photograph of Brad Weber's cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph by Mr. Weber's white cargo van on Exhibit 3D appears to be at least similar to the white cargo van it appears in Exhibits 3B and 3C. The zoomed video clips and zoomed still photographs paired from Exhibit 3A, the original security camera recording. Other video files produced by the security camera in the state's possession provided to the defense in discovery, covering the time from 2 p.m. to 4 p.m. February 13, 2017, do not show any other van driving north into the private drive on the Weber property or traveling east during that time. Exhibit 3A, 3B, 3C reflect that if Mr. Weber returned home in his white cargo van, he could only have arrived home minutes after 2:44:54 p.m. February 13, 2017, 12 minutes after the time the extraction of LG cellular telephone shows the telephone stopped moving at 3:32. So, I mean, it's not the most clear video, but if there is other clear video, and those who follow the trial might know how clear it is, if there's clear video showing there were no other vans that match that description, it is a little weird, that this time frame isn't matching if that's the only one that could possibly be on the road. But again, roads have a lot of side roads, and someone could have pulled out of a garage, or there's a lot of different things that could have happened here. Either the white cargo van showed Exhibit 3A, 3B, 3C as Mr. Weber's with him arriving home some minutes after 2:44:54 p.m. on February 13, 2017, or it is not. Yes, it is one of two things. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. at or before 2:32 p.m. on February 13, 2017, the time the extraction of LG cellular telephone shows the telephone stopped moving. Defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber. Ooh, are they going to say this guy did it? And is dated March 3rd, 2017. The unredacted version of Exhibit 3E was provided to the defense by the state and has thereby been in the state's possession. The FBI subject information sheet for Mr. Weber says, on February 13, 2017, Weber's phone pings to parents' address overlooking the crime scene initially at 2:50 p.m., repeatedly pings around the property until 11:55 p.m. Then Mr. Weber's phone first pings at his parents' address at 2:50 p.m. on February 13, 2017, is consistent with the video evidence in Exhibits 3A, 3B, 3C showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:54 p.m. that day. Okay. You know what? I was so skeptical as an outside viewer coming into this. Very skeptical with that video footage. I think anyone would be. I'm so skeptical. But phone pings add to it. Huh. Okay. From both Exhibit 3A, the security camera video recording, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited, or failed to correct once it had been elicited. When the state introduces testimony it knows will be false, or fails to correct testimony it knows or should know to be false once elicited, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. I mean, it's fair to say that claiming the defendant did a confession that with information only the killer would know would possibly, very well, could have affected the outcome of the trial, right? And if the state knew it was false, that's not good. But if the state, did the state know it was false? Because if the state knew it was false and the state provided everything to the defense, if the defense didn't know it was false, did the state know it was false? I will say that cell phone pings do seem a pretty easy check, right? Is our witness, like, people are always wrong about when they arrive home, when they get someplace, right? No one's accurate unless they looked at a clock or are purposely going there for a certain time. I would expect you would check cell phone pings. If you're checking cell phone pings in general, you would double check, right? Like, that seems, maybe that's too much, but I don't know. I would think a double murder, I would check the cell phone pings of who I'm going to try to base my case around. But hey, they got the conviction, right? But did they? It's good. Ugh. It's making me think of just the prosecution, and of course I know it's being painted this way. It seems like they gave him a lot to work with. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Wallow's rendition of Mr. Allen's statements that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of murders that might be true. There's a note there. Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither was buried in a shallow grave. The state, therefore, cannot show Mr. Weber's uncorrected, false testimony at the time he arrived home did not have an effect on the outcome of the trial. I'm going to finish this segment before I talk. Alternatively, for the court to find the state did not know or should not necessarily have known about Exhibit 3A, the security camera, and Exhibit 3A, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result in a new trial. Accordingly, for either reason, the court should have vacated Mr. Allen's convictions. So basically what they're saying is the state purposefully gave false evidence to force a conviction, or this is new evidence that probably, put that in quotes, probably would produce a different result at trial, or have a different result. I would say, if you're the jury and the time frames don't match, maybe it has a different impact, right? And also this confession of murder that they're going off of, as they said, had two things that didn't happen. Now we have a guy who's they're saying has psychological issues, possibly illegally I'm using their word. Let's just use the wording that the defense is using here, right? Like the way they're trying to portray this. A man is arrested. His rights are violated. He is then put in solitary confinement and tortured until he gives a confession that does not match reality. None of it matches reality. The only thing that they could find, according to what they're saying, that matched is a white van. A very generic vehicle. And it could have been a white van they saw that day while out on a walk, and they just threw it in their psychotic state. To me, that is how they're trying to present it. We have more. Ron Logan's confession to Reese Davis before May 15, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Dr. Core was a forensic pathologist who conducted the autopsies of LG and AW. His original opinion, held for years, about how LG and AW died was that two weapons were used, one a serrated blade, the other a straight-edged blade. For the first time at trial, having had a eureka moment at his tool bench, Dr. Core opened that the girls could have been killed by a single box cutter rather than two different knives. Defendant's Exhibit 4A is attested to by Matthew Hoffman, and Defendant's Exhibit 4 is a redacted copy of a tip of the Orion database of tips dated May 15, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Reese Davis sometime before May 15, 2017, while they were in prison together, that he had killed LG and AW. The material part of Ron Logan's confession to Reese Davis, as appears in Exhibit 4A, is produced below. Logan confessed to Reese step-by-step of killing the two girls. Logan told Reese how he burned his clothes in a fire pit where it was located, used box cutters and struggled with one of the girls, and thought drops of blood from his nose ended up on her clothes. Reese also advised that he killed the older girl first. Ron Logan's confession to Reese Davis is reflected in the tip of the Orion database, and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matthew Hoffman, Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police Sergeant P. Hansard about the interview with Reese Davis on June 21, 2017 at the New Castle Correctional Facility regarding Ron Logan's confession to Reese Davis. Those handwritten notes of First Sergeant Hansen are attached to the Indiana State Police Detective N. Wolf's lead narrative summary cover sheet, as it was provided to the defense in discovery. First Sergeant Hansen's notes of his interview with Reese Davis about Ron Logan's confession provide even more detail. Please don't make me have to read that. Hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Reese Davis. Exhibit 1, page 1 of Exhibit 4B is reproduced below. It seems to say, I'm not going to try to read this. Chat, I'm not going to try to read this. I'm going to read what they say it says, because I've done enough of Sarah Boone handwriting reading. I can't read this. Walking, talking about knowing one of their dads, to walk with them. One of them wanted to turn around, grabbed younger's shoulder. It's okay. Oldest freaked out. One says something about calling police. Sexual attack wasn't true. Originally not trying to go rape them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. Top half of page 2, Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. He started talking. Ironic, should have been in school, knew one of their moms, waitress at a bar, animals, walked with them, willing to go check out horses, he XXX. He told them he had rabbits in barn, walked through trail in woods, oldest paranoid, didn't want to go, youngest wanted to see horses. Top half of page 3, Exhibit 4B is reproduced below. It seems to say, oldest turned to help youngest, oldest started looking, kicking, youngest seemed. He now grabs oldest. He said he got hit in the nose, scared he got blood on one of the girls, pulled box cutter out, slit oldest, one hit in artery. Youngest scared, etc. Took little girl with him a while, never said where. He said he cut her to cut both necks. Bottom half of page 3. It seems to say he left again, came back later in the evening, search going on. Later 4 hours, tried to move oldest one to area not going to be found. Place where four-wheelers blank go. burned his clothes in burn pile, hiking, walking, boots, gloves, bag. Top half of page 4, Exhibit 4B. Sole of boots be in burn pile. Next morning, 2 other girls knocked on door, asked to search on property. Felt weird if he said no. He let them take off. Got hold of family member and got out of area. Bottom half of page 4. It seems to say, first time he's seen them from property, home, etc., guns, etc., during struggle, youngest not, happened to friend to stand there, head, neck, artery. Defendant's Exhibit 4C is a handwritten note signed by Reese Davis, dated June 21st, 2017, the same day First Sergeant Hansen interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet. It's contained in the same file as First Sergeant Hansen's handwritten notes that are in Exhibit 4B. Reese Davis's handwritten note about Ron Logan's confession to him says, Mr. Logan has made reference to the killing of Delphi, Indiana. He told me he was the one who had killed those girls and it got out of hand. He walked with them in the woods to his property and the girls wanted to turn back. Said something about walking the blank. He grabbed the youngest girl to reassure her it was okay, however they panicked, and he was also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me he killed both of them because it was took too far. In addition to the other detail that fits the known facts, Ron Logan confessed to Reese Davis that he used box cutters to kill the girls. If instead of for the first time at Mr. Allen's trial, Dr. Kaur had 7 years earlier said the girls could have been killed by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' murder. As it was, the FBI, 2 months before Ron Logan's confession to Reese Davis, had obtained the judicial findings of probable cause to search Ron Logan's property. Under the circumstances, Dr. Kaur's target testimony about a box cutter probably being used to murder the girls makes Ron Logan's confession to Reese Davis newly discovered evidence that would either be admissible through Reese Davis evidence rule or through the First Sergeant Hansen under the Due Process Clause of the 14th Amendment. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at every trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. If the doctor, at trial for the first time, declares suddenly it's a box cutter, and that guy is in the files, and that wasn't brought up at trial or investigated more, I don't know. I mean, those notes aren't good, but and people confess to things they didn't do. Here we have more. Defendant's Exhibit 5. The affidavit of Stacey Eldridge states that dirt or water damage to the phone could not have caused the auxiliary jack on LG's phone to log wired headphone plugged in and wired headphones unplugged. Ms. Eldridge's expert opinion is newly discovered evidence would probably produce a different result in a new trial. At trial, Mr. Allen introduced evidence to the testimony of Stacey Eldridge, a digital and mobile forensics expert, that someone plugged wired headphones into the auxiliary jack of LG's phone at 5:44 p.m. on February 13, 2017, and unplugged it at 10:32 p.m. the same day. To counter this, the state offered the results of a seat-of-the-pants Google search by First Sergeant Cecil, the state's phone expert. According to First Sergeant Cecil, Google hearsay told him, in his expert opinion, that is a wild. Google hearsay told him in his expert opinion. That was worded to elicit a response for sure. The log on LG's cell phone showing wired headphones were plugged in the auxiliary jack at 5:44 p.m. on February 13, 2017, and unplugged at 10:32 p.m. that same day could have been caused by dirt or water damage to LG's cell phone. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should read Miss Eldredge's affidavit, Exhibit 5, in its entirety, but the short version of Miss Eldredge's actual expert opinion is nothing in the data on LG's phone indicated there had been water damage. None of the reports or extraction related to LG's phone created by law enforcement officers reflect dirt or water damage to the phone. Photographs of LG's phone taken by the Indiana State Police did not show the photo to be wet, dirty, or covered by debris. Miss Eldredge is unaware of any scientific or technological research suggesting that dirt or water damage to an iPhone 6S would cause the phone to inaccurately wire logged headphones in or wired headphones out. So, it's been a while since I've had an iPhone 6S, but I have had an iPhone that got water damage. And there are, unless I am terribly misremembering, indicators built into the phone, like kind of like paper, that actually change color with water. So that could have been logged. As for dirt and stuff saying that your headphones are in, I've had iPhones for years. I've had them keep working after getting in water. I've had them with tons of dirt and debris in the headphone jack to the point where I've had to take like paper clips and like scrape around in there. And I've never personally seen it say that the headphones were in when they weren't. But I mean, I would trust this expert over someone Googling. Especially with how when he says Google, I wonder if they showed how this Google search was done as well, because Google likes to pull stuff from like AI now. And God, if this ends up being the case, this is going to be the talking point. If this ends up being the case, Google sometimes pulls information from websites with AI that are completely and utterly wrong, right? Like stuff that's dangerous and inaccurate because people will make a joke somewhere or just confidently say something is wrong, and because it was said enough on Reddit, it now shows up at the top. So, oh boy, if it ends up being AI that told him the wrong thing, if it ends up being wrong and it was from AI, that's going to be so much media attention. According to the Apple Health data on LG's iPhone 6S, the phone stopped moving at 3:32 p.m. on February 13, 2017. At trial, the state contended LG and AW died close to the same time. AW hid the phone under her body before she died. The state also provided testimony by former Delphi Police Chief Stephen Mullen and Indiana State Police Lieutenant Jerry Holman. There was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbaugh on that time and that location and that time at 3:50 p.m. on February 13, 2017. If Miss Eldredge's actual expert opinion that wired headphones were plugged into LG's auxiliary port at 5:44 p.m. on February 13, 2017 and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling LG's phone multiple times long after the state contended Mr. Allen left the scene 4 p.m. on February 13, 2017. It's weird in another way, because why would someone plug in headphones at 5:44 and then unplug them later? I'm trying to think of a scenario where you'd plug headphones in. Is the time of death certain, or are they just going purely, almost purely, off the phone not moving? Because I guess there could be a scenario where you convince the girls to plug in the headphones as like a distraction or something, and maybe music's playing or something. They kill them. They go home, and then they go, "Oh no, the music's gonna have the body be found," and they rush out and unplug it. I don't know. Miss Eldridge's opinion that dirt or water could not have caused LG's phone to log wired headphones being plugged into and being unplugged from the phone on February 13, 2017 exculpates Mr. Allen and would probably produce a different result in a new trial. According to the court, should either vacate Mr. Allen's convictions or set this motion for a hearing. The matters set out and attested to above, taken individually or cumulatively, entitle Mr. Allen either to have his convictions vacated or have a hearing on those matters. For the foregoing reasons, Mr. Allen respectfully requests the court either vacate his convictions or set the matters above for hearing and for all other just and proper relief in the premises. Is it enough? I think in the court of public opinion, the amount of people calling for a new trial has to be going up. I haven't checked. I have to imagine it's spiked. Because I think anyone with any doubts in the case see this, and not saying that they think he's innocent, but they might think that there's enough here that if this was there, it could have given probable cause to a jury. Huh. You know, I went into this expecting it to be like Sarah Boone's, where I kind of laughed at it, all her claims. But maybe it's because I didn't follow this case enough. And of course, I'm just seeing the way they're wording it right now. They've painted a picture of a man arrested, illegally moved away from his lawyer, kept in solitary, and tortured for an extended period of time. Psychotic, gives a confession that doesn't match reality with the claim that the state hid that fact knowingly, possibly knowingly. That an expert changing their opinion at the trial at the last minute then declared a weapon that could have implicated someone who confessed prior. The phone thing, I think, is the least, to me, is the least convincing, right? I understand why it's there, right? It adds questions of what's going on there. If the expert is right, it couldn't be from dirt and water. That's weird. It's something that needs to probably be explored. If the expert the state's going off of was a Google result, that's not good. I could see it. I could see it. That's what I'll say. I could see a new trial. Now, this is my first time going through, so I'll tell you what I'm going to do after this is while I'm editing this, because I got to combine some stuff together. I'm probably going to watch. I don't know. Someone else has to have reacted to this, right? I'm gonna follow them and see what they say. Someone who's able to follow the case more. Yeah, I think in the court of public opinion, the calls at the very least are going to be increased. With Sarah Boone, when they listed out reasons, they were very clearly no one, I don't think anyone was like, that's right, or like, that is a problem. Maybe it's a better lawyer team. I don't know. But I can feel that here. And am I misremembering, or was this like already an expensive case for like a small county and all sorts of stuff? So, oh boy. Now, with that being said, I'll add for anyone that's here at the end, like a little channel update. I am still planning to cover. My brain is so fried from being sick. The other case I've been covering in order. I'm still planning to do that. I'm just sick. Um, with all the talk of tariffs and stuff increasing, and with my computer getting up there in years, um, some of my focus has been trying to see if I can find something I can afford to do, like a swap, get something else, because I'm afraid prices might go up on some of the stuff I need. Um, and next month is going to be a big month for gaming anyway. And I have a gaming channel with like, I don't know how many subs, a lot of subs, like 12,000, 13,000, not as many of this, but a decent amount of subs. And if I were to make content, I'm gonna be honest, I'm afraid I'd be like doing content for a game and my computer would die. That's the point I'm at, right? So I'm looking at prices, seeing what I can find, trying to find a good deal. And because I'm still sick, and I'm gonna be honest, it feels like I'm never not getting sick. Instead of trying to build, I'm looking at pre-builds right now. If I can find one that's maybe like last gen going on sale because the new stuff comes out this month. So that timing's good for that. So that's taking a lot of my like thought process and thinking power because it would be a big purchase and I'd have to make that money back, right? That's a lot of money. So yeah, very very not feeling well. I know it's warm in this room right now, and I've had the hoodie up because I felt cold. Um, throat kind of burns. I don't know what it is. I took a COVID test and it was negative. I'll tell you that I took a COVID test and it was negative. Um, and I'm not really wanting to go out and, like while feeling like this too. Um, so yeah, just thought I'd do a little channel update at the end. I do these sometimes. Um, definitely, if this case gets a new trial, um, I might try to cover it because I wanted to cover it before, but it was there was no video feed. It was so hard to find stuff, and I was already covering Sarah Boone. Um, I'm gonna be honest though, if there's a retrial, um, do they just do a change of venue at this point? I feel like if they do another trial, change of venue might be appropriate. But yeah, I'll see you in the next video. Not sure when that'll be. You know me. I get sick. I say I'm not going to do long videos, and I put this one out anyway, and then things will pop up and I'll do them. So just see you the next one. Hope you enjoyed. Let me know what you think. I was swayed a little bit. I'll say that. Am I swayed enough to saying he deserves a new trial? I don't know enough about the case. Um, but I think in the court of public opinion, there's going to be more calls. And as much as people are like, the public's opinion doesn't really matter, it's pressure.